Advocacy remuneration order and being for lawyers, which is very, very important. This session will be led by Advocate Aisha Sinda from Bamans. For interest of time, I cannot lead the bio, but allow me to invite Aisha Sinda to take the floor. Karibu Aisha Sinda. Makofi kwake as she's coming to the podium. So this will be the last session for a day. You're welcome, Aisha.
Good evening, everyone. As I was introduced, my name is Aisha Sinda, and I'm a senior associate at LawCon, Tanzania, and I'm a moderator for this topic, Dissecting the Advocates Remuneration Order and Billing for Lawyers. So I would like to welcome my esteemed panelists. Mr. Henry Mwinuka, Madeline Kimei, and Kenneth Mohangi. Please welcome to the podium. So, as I said earlier, our topic is dissecting the Advocates Remuneration Order and Billing for Lawyers. And our first panelist is Mr. Henry Mwinuka. And Henry is a co-founder and partner at Avis Legal. He has also taught law at the Faculty of Law Tumaini University in Iringa, and his areas of interest includes cyber law, corporate law, and investment law and arbitration. Mr. Henry Mwinuka will focus on the law governing advocates' remuneration in Tanzania, and he will briefly discuss whether the rates are fair in comparison to the work output by lawyers and whether there is a need for it to be reviewed. Welcome, Henry.
Good afternoon, everyone. I know we're very exhausted. We have been here since morning, but what we are trying to get here is actually giving us an appetite to proceed. Well, yes, because of time, I will try to be very quick, because actually this area, dissecting the Advocates Act in terms of the remuneration and the billing orders, it's a very important topic, or important area of concern for every lawyer. Why is it important? It is very important because it touches upon the livelihood of lawyers. Over a span of time, it has always been believed that lawyers should only issue services, and our profession should not regard itself as business or trade in that case. However, the trends have been shifting over the course of time, and now I recall in several occasions the Chief Justice of Tanzania, Professor Ibrahim Juma, has always tried to urge the members of the community and the entire profession to regard law as business, because at the center of it, lawyers' lives also lies there. So we cannot pretend that whenever we want to talk about cost and whenever we want to talk about the income of lawyers, then no, this is not actually business. This is a service. So in that case, I will also follow suit by trying to argue us to see law as a source also of livelihood. Now, the laws that govern the issue of remuneration and billing of advocates, among other laws, is the Advocates Act 341, which actually is the parent act when it comes to advocate issues. Well, another is the Advocates Remuneration Order, which is under GN 264 of 2015, and this is actually mainly under Section 49, sub-regulation actually, Section 9, subsection 3 of the Advocates Act. Also, there is the Advocates Professional Rules of Conduct and Etiquettes, which are actually also regulating issues of advocates' charges and billing in general. Now, quickly, the issue of advocates' remuneration orders plus other laws that regulate issues of remuneration to advocates. If you ask me personally, my opinions about their strength, the first is that these regulations or these rules are actually very exhaustive compared to the 1991 rules that have been repealed by these ones. They are exhaustive in terms of that they cover both contentious and non-contentious matters. And actually there are a lot of specifics in terms of what the advocate can charge and in contentious matters and non-contentious matters. So they are very exhaustive on my opinion. Now, on the issue of scales as well, scales that advocates are supposed to charge to clients, I also believe that the scales are reasonable. Are reasonable in the sense that they have tried to balance the public interest that the society, we have the people who have different level of economic income, and at the same time also at balancing what advocates does and their right to earn their livelihood. So the scale is in a way reasonable to me. And why am I saying that? To measure whether the scales are reasonable or not, it is also very important to have a comparative analysis or study for that case with our neighbors, for instance, Kenya and Uganda, and we'll see a bit later. Now, about the challenges of these remuneration rules of 2015, first is that less efforts in implementation. Even though our rules are a bit fair, but there are challenges in terms of implementation of these rules. Why? Because there is this what we call a deep-rooted culture of undercutting. And for young lawyers, they will understand what I'm saying, and also even senior lawyers, they are in conflict because at one point you might come across a client and then you try to explain to them. I remember there was one scenario, me and my partner had to write almost 3-page explanation of our justification of our legal fees. And this was a client who came outside and wanted to register a company in Tanzania. And the rules are very clear that when you charge them, you should also look at the amount of share capital for that company, so that you can also be able to charge the necessary fees. But this very same client met another lawyer somewhere. And then this lawyer said, how much did they charge you? And then she said, almost 10,000 USD. She said, the other lawyer said, this is very expensive. You can get it for barely 2,000 USD. Can you imagine? And this is a foreigner. So we had to even attach the advocates' remuneration rules to bend them with the explanation later, to justify to the client that we charge you according to the law. But yet, there is an alternative to this other lawyer that they can offer the same level of services for a relatively cheaper amount. So there's a deep-rooted culture of undercutting in our profession. And this has caused turmoil within the profession, and when it comes to issues of charging clients. We always have to justify what we deserve in that case. Also, there is emergence of new players in the market. You know, agencies performing legal tasks. Right now, you don't need a lawyer to register a company. People have what we call connections in Tanzania. So someone can just register a company without actually talking to any lawyer here in town. And this actually has also made clients to look to lawyers as alternatives, or sometimes as an impediment. But remember, these very same people who are, let's say, registering company or doing some other things that lawyers have to do, they cannot do due diligence actually, because they are not lawyers. You have to go through a lot of laws to make sure that the client is well served. But they are there, they are allowed, they have business licenses, so they have justification to do whatever that they do. Another challenge is that the saturation of legal market, particularly in big cities like Dar es Salaam, Mwanza, Arusha, every lawyer wants to be in these cities, almost. So the problem is that we have too many lawyers, we have few clients. And consequently, because these lawyers actually depends on law for their livelihoods, they end up compromising now the issue of billing and the issue of remuneration. Because they have, I remember yesterday I was talking to a senior advocate brother and asked him, he said he had to fire a junior lawyer because there was a client who went there and said, for this service, the senior said, I cannot accept 2 million Tanzanian shillings because that is very minimum. And then the junior advocate actually was wondering, why would you say no to 2 million? Because for him, that 2 million is too much money. And then what they do, they go around, they talk to the same client that I can offer this very same service for 2 million as you requested. You know, my senior is not understanding. So it's a problem. So we have too many lawyers, and sometimes it is a conflict of survival and professional ethics. But these rules, if they were fully implemented, no lawyer would actually complain about the extent of fee that they have actually allowed. But because we are not, actually the amount is fair and we are not charging it as a profession. So it's up to each and every law firm or lawyer to decide what actually to charge a client. And this is causing turmoil, as I say, in the issue of trust, dishonesty. Some lawyers who abide by these rules may look as if they are very expensive and they want to steal from clients. You know, and those ones who can go relatively low, they may seem to be accommodative of client interests. Now, whether the rates are fair, by comparing to Kenya and Uganda, TZ rates are relatively low and high in some respects, so it depends. For instance, I'll just pick a few examples. Registering one trademark in one class in Kenya. I tried to put in Tanzanian currency. In Kenya, it is almost 817,000, almost 800,000. But in Uganda, it is 600. In Tanzania, it's 200. You see? So, in that case, Tanzanian rates are very low. And I don't know whether for a citizen or a client, that is relatively good and fair. For matrimonial cases, for instance, divorce and separation, where the proceedings are not defended, in Kenya it's almost 300. In Uganda, not less than 600. In Tanzania, it is 300. So you can compare. Because to say that whether we are charging low or high, sometimes we need also to check our neighbors, what are they really doing in the same areas. Winding up proceedings in Kenya, it is 400. In Tanzania, 2 million, 0.5. So in that case, one may say that the winding up procedure of companies in Tanzania is relatively expensive as compared to Kenya. And on the sale of immovable properties, if the subject matter, let us assume the subject matter is 70 million. What will be the charges for a lawyer in Kenya? It is 1.9 million Tanzanian shillings. In Uganda, it is 2.2. In Tanzania, it is 3.5. So in that case, our charges are relatively high. Now, based on the study that I actually did, the little study I did in the rules of Kenya, which are of 2014, and that of Uganda of 2018, and the rules of Tanzania of 2015, I have actually came up to a conclusion that our remuneration rules are not really law, but they are not implemented. Even at where they are law, they are not implemented. So it's upon for the lawyers or individual advocates or the firm to charge in their own accord. And in that case, it's very easy for someone to circumvent these rules because there is no mechanism of...
Apologies, Henry, would you wind up?
Yes, I am winding up. So what should we do? Actually, we should first enforce them strictly. And when we have enforced them strictly, the rules that we have, then at least we can investigate the seriousness of the matter. I mean, the issue of non-compliance, why are people not really complying? And also to have a mechanism in place that compel advocates to charge as per the rules. We cannot say that they are not good, they are not okay, while we don't even follow them in the first place. So those two things that I would recommend, that we investigate the seriousness of the matter. We have a serious problem of undercutting, and also to have a mechanism in place now, TLS and us, Stallion and everybody else, to have a mechanism in place that can help us proceed with charging according to the rules that we have. Thank you.
It goes so smoothly. And that I have 10 minutes to present on the advocates' remuneration order, the GM that has been discussed by my colleague. But I'll be looking at the arbitration practitioner. How does that practitioner use this order to comply to the public policy with regards to how you remunerate advocates appearing before arbitral tribunals? And yes, it does apply to arbitral proceedings. At the very onset of its preamble, it speaks of arbitration proceedings. It goes on in order 40, also making reference to arbitral proceedings. However, the remuneration order itself doesn't give us justice. It does not give us that means that we need to be able to be guided through on how to build. How do we build for us to be financially sustainable in business as arbitration practitioners? When I say practitioners, those advocates appearing before arbitral tribunals to defend the matters for their cases. At the very beginning, I would want to say that the arbitration lawyer's experience vis-a-vis the litigants or the litigation lawyer is very different. We all understand that arbitration is an out-of-court mechanism. And so the process, and this is enshrined as an objective within the Arbitration Act that is a revised edition of 2020, the objective behind it, if you look at Section 5 of the Arbitration Act, it goes on to say, it refers to without unnecessary delay or expense. So this comes back to bite you when I go back to my presentation now, that starts off with what are costs in an arbitration? Do we do the same bill of costs process that we usually see in a litigation? No, it's a different experience altogether. In an arbitration, the law guides us. as to what costs amount to. What consists of costs? If we look at our Act, Section 61 and Section 62, starting from those sections, and I have not put them on there because I've been looking at it for too long, but it's Section 61 which deals with costs and gives you 3 elements of what costs in arbitrations are. It includes the element of legal fees, and that's what I'll be discussing, that element of legal fees. The other elements are the arbitrator's fees, and then the third is if there's any administrative body that needs to be paid its administrative costs, that also is factored into what costs are in our regime right now. Now, side by side with the regime, which is enshrined in our Cap 15, we also have to look at the applicable rules. Now, if you have the rules, which are the unicitral arbitration rules, which are really what we borrow to come up with our own rules in most institutions, because the unicitral usually sets the footprints, and we just follow. And so if you look at the TAB rules, if you look at the ICC, International Court of Arbitration rules, the revised editions of 2021, if you look at the London Court of International Arbitration, if you look at the Singapore, you look at any institution, there is an element of that rule, of those rules that cover what costs should consist of. And maybe if I can go through the drop-down, for example, with this new Tanzanian Institute of Arbitration rules, 2022, under Article 26 of this regime, we have outlined what the term costs includes. And item 26.221 says the fees of the arbitral tribunal. We go on to say the reasonable travel expenses and so on, costs of experts and witnesses, and then if you go down all the way to item 26.26, we speak of legal costs, legal fees. That means the costs you incur to have legal assistance. Now, enough of my presentation. Who here thinks that one needs a lawyer to be in an arbitration proceeding? Does a party need a lawyer? Absolutely, okay. Anyone else? Who has a different kind of thinking? Do they need lawyers? They need lawyers, okay. We would say that to ourselves. I say they need a lawyer too. But the whole objective behind alternative dispute resolution is that the parties have freedom of choice. The principle of party autonomy is always preserved. So if you look at the Arbitration Act, for example, it always starts with the sentence, unless otherwise parties agreed. So that means they leave it to the room of the parties to negotiate what they have, what they agreed to. Do we need to have legal representatives? And how do we handle the cost element? How do we allocate costs at the end? Do we have the right to claim costs before the arbitral tribunal or not? Do they include legal fees or do we exclude legal fees? And so it is all back to the parties' autonomy, yes. Now, if I'm to speak further on legal costs and legal professional fees and how they affect the arbitral tribunal, their arbitration itself, it would go back to the rules and if there was any agreement between the parties that affect the allocation of costs of those, especially those legal fees. And we do have instances where parties had entered an agreement that indicates that legal costs will not be recoverable. And what the advocate's remuneration order, what that guides us through is that we charge reasonable fees at the percentums or the thresholds that they have indicated in the order, of course with leeway here and there with regards to looking at the complexity of the matter and so on and so forth. But in the arbitral process, what happens is that you do not file before a taxing officer. It is at the end of the arbitration where you have your closing submission, that at the end of with your closing submission or separate from your closing submission, you table in your cost submission. Why? Because the arbitral tribunal is vested with the power to render an award on costs. The award can come at any stage. If there was a partial award, then he may render a partial award of costs and reserve all other costs to the final award. Or he may opt to issue a final award and render an award on costs after the event. It depends on how that arbitration has played out. And so it is not the taxing officer, it is the arbitral tribunal himself. And when you lodge that final award that has an element of costs, that the legal fees have been won at the High Court or any court that you may be seeking for recognition and enforcement, those are the parties' won elements. If they did win the legal fees, then it cannot be, if they did win, it cannot be challenged before a taxing officer because their award of the arbitral tribunal is final and binding. So these are where the differences are. Now, how do you charge? This is where I usually have a field day. I'm as bad as billing as any of us here. But what I look at is one, the amount in dispute. Two, the parties. Three, the opposing counsel. Why I look at the opposing counsel is that it depends on the counsel on the other side if these arbitration proceedings are going to go in an expeditious, without unnecessary delay sort of format. But if you anticipate that there will be a lot of challenges coming forward, then you need to really, really look at your fees. I've had this problem, I think, in 2 arbitration proceedings that I've acted as counsel in, where I had charged a fixed fee, yet along I came about, roadblock after roadblock and after roadblock, but I have to show up for my party. And, of course, at the end of the day, one of those cases, they were able to amend my fees, considering that they did understand the kind of roadblocks as opposed to what I had put in scope of the work. The roadblocks that I had to go through were slightly different from what was in the scope of roadblocks. You cannot anticipate your adversary's strategy in a case. And so as the strategy changes, sometimes it welcomes further negotiation of your legal fees. And so, yes, we are guided by the Advocates Remuneration Order, but not so much because it does not provide for specific guidance in terms of the billing. And so we go back to what we usually use, the percentage that are outlined there. Why I use the Advocates Remuneration Order to guide me is because of public policy. This is our public policy, in-country public policy. And I'm speaking of only arbitrations that are seated in Tanzania. If it is an international arbitration, I will do slightly more different in my approach for legal fees. Why? In an international arbitration, you're not bound by the public policy that is tightening you here in the domestic arena. In the international platform, you're able to charge via the kind of work and, of course, your negotiation with your client. But it should not be unreasonable too, because if you appear before me as an arbitrator and I find that your fees are unreasonable, and when I'm awarding costs, what we do is look on how to allocate or apportion the costs. Maybe, as guided by Section 62, the new doctrine of costs follow the event, I will say, okay, so the claimant succeeded, but do I give them 100% of their legal fees? I don't want to. I'm going to deduct 20%, one, because the claimant never showed up early for their meetings, for the preliminary meeting, for example, or the hearings, or the counsel for the claimant is a little bit, not presenting their points in the manner that it would be understood by the other party. So there are other factors that you could consider and you need to look out for when you're setting the fees. The reasonability, how you present your case, how you appear before the arbitral tribunal, because they will consider it. The actions of the parties during the proceedings are considered when you're awarding the costs. And that is my point on that. Now, legal cost survey, the last survey that I thought of and was able to get a hold hold of was the Chartered Institute of Arbitrators survey that was conducted in 2011. And that survey really just puts a pin right in the middle.
I would appreciate
I'm
it.
also running out of time.
Yes, please, sweetheart.
I thought I would have some favor. But I am about to wrap up. And so this survey was conducted over 254 arbitrations, and as you can see there were numerous institutions involved, and the average international arbitration legal fee stood at that GBP, which is about 1.6 to 1.8 million dollars. These are international arbitrations, and usually those fees really do spike up when it comes to these kind of cases. And so I did speak already on how I would consider a practitioner should go about in considering their billing format, whether you're going to be doing it in an hourly or fixed basis. We have seen the build-up in boutique firms in Tanzania. I've seen a lot of boutique firms come up. The boutique firms can charge a lesser sort of, I find that they're able to charge slightly on the lower end as opposed to the global sort of companies or law firms that are present. And so boutique firms also affect our way of billing. The key factors, as noted there, complexity, monetary value, nature of the dispute, and the procedural elements, meaning anticipating whether the other party will have to challenge, for example, the jurisdiction of the arbitrator, and so on and so forth. This slide speaks to something that I think is very important. We know that we have this rules, the rule of charity applies in our practice in our country, and that we cannot go ahead and generally say that this can be it is prohibited in our country. It is not prohibited. However, I recall a presentation that we did before the parliamentary committee that was working on the Arbitration Act. And what we did was that we wanted to expand their thought over thinking about allowing this contingency fee arrangement in arbitrations, and more specifically in international arbitrations. And that what that would allow is we would move through this emerging trend of introducing third-party funders, TPFs. TPFs are becoming more and more common. The new acts or the new legislation around arbitrations in certain African countries, for example, Nigeria and Sierra Leone, they have put this in their legislation so that to allow access to justice, because with a third-party funder, you're able to access funds in order for you to obtain the service that you need. And so I think that would be it from me, Aisha, and I'm welcome to receiving questions. Thank you very much.
So, my request that I stay seated so that we can just go straight into the Q&A. All good? Very good. Okay. So, mine will really just segue from Henry's presentation. I'm looking at the business of law. Okay, thank you. Much better. So, as I mentioned, I'll segue from Henry's presentation, really looking at the business of law, and just try to share just a few tips before we go into the Q&A, if there are any questions that you guys left may have. I'm aware that we live we operate in a relatively free market economy. And so the question that I always have is, if we live in a free market economy, and we are at liberty to be able to build or to be able to do business the way that we do it, do we really need the advocate rules? Do we need these rules on remuneration to guide us in terms of how we build? I would look at it in two ways. One, I think, although we do live in a free market economy, it's important if you're operating in the professional services industry to be able to guide, especially the practitioners that are just joining, the profession as to how we can build so that we can avoid something Henry mentioned around undercutting. I realize that as human beings, really, we thrive a lot in communities, we thrive a lot in the swarms that we operate in. And if that is the case, I think also with billing, if we collaborate a little bit more, to be able to understand what one firm is billing, to be able to understand even across borders, so that when these clients are coming to us, we're all united in how we present the bills that we present to these clients. I think ultimately billing also follows the law of cause and effect, in the sense that if we are shy or if we are secretive about the bills that we charge, other than the guidance that's given from the law, but as lawyers ourselves, do we consult each other when it comes to billing, to be able to understand particular areas of law? For example, I specialize in technology, and so if I was billing a client in that space, would that bill be commensurate with a bill from a lawyer in Tanzania over the same services that I'm offering? Chances are that if we have bills that have very huge disparities, then you find that that particular market will continue to remain how it is. But if we are united in how we bill these clients, if we collaborate, if I know that I'm billing a client and I go to Stallion and Shezada knows that Kenneth will not bill below this, or I know Shezada will not bill below this. So whether the client is coming to Uganda, whether the client is going to Tanzania, whether they're going to Kenya, whether they're going to Joseph there, it will not matter. Ultimately, we shall be billing a fee that may be or should be commensurate with the work that you're doing across the board. And then, of course, beyond that as well, I would think perhaps other tips that I would give legal practitioners in the room in terms of billing, understand the models of billing as well. Usually, from the sources of law that we have adopted hourly billing models. But do these models actually really work with our firms in East Africa? Do they work with our clients in East Africa? Can you comfortably get the amount of money that you would want if you were billing hourly without chasing away the client? And so that's a very good question. And so the guidance that I'll give there, other than the hourly, of course, we also have retainer arrangements. You can also be able to bill per transaction. But the advice I would give is you can still be able to prorate your hourly rate and come up with a figure that may be a one-off figure that a client may find palatable, and as such you're able to keep the client, but also will ensure that you're not billing below a certain amount of money that you'll be billing otherwise. Then of course, if you're also billing, how are you going to negotiate the bill? Are you just going to send an email to the client, especially if you're trying to justify a very huge bill? Because sometimes we open ourselves up to many questions, to a lot of scrutiny. But sometimes I find, in my experience, that speaking to clients when you're negotiating a bill, you find that you have less back and forth. And in that light, you find that the bill, it is easier to justify a bill when you're speaking to a client, and the client is really seeing what is coming out of your mouth, seeing and hearing. And that way, you will find you're able to justify a bill, and a bill that will make you happy and make the society happy in general. One of the presenters this afternoon also spoke to us about branding. I think branding is a very important aspect of billing. I think one, where your chambers are, you yourself, how you present yourself as well. In many instances, your bill will reflect how you look. Unfortunately, that is the truth of it. Perception in our country, perception in our societies, perception in our world matters a lot. And so the perception that you portray to a client before you bill will make or break you if you're trying to justify a bill, especially one that you want on the higher side. And then of course, the output, the work that you're going to put. Sometimes we focus so much on quantity that if I'm going to send work, I'm going to send many, many pages, and perhaps that will show the client that I've done a lot of work. But I think what we forget is that for many of our clients, what they would prefer is the quality over the quantity. And so I think that's something that has really helped us, as I say, I'm speaking from Uganda, for Ugandan lawyers to be able to focus on that quality aspect. Because if you focus on the quality, again, it will be very easy for you to be able to justify a bill overall. And then I think I will end as well with understanding the nature of the client. Ultimately, I think the challenge with having a one-shoe-fit-all approach is that one, you find you'll underbill a client who perhaps you'd have billed more, or you will overbill a client who then go to another person. So in the technology space, for example, you find that you have startup companies, you have early growth companies, you have mid-growth companies, and then you have the more established companies. Each of those companies will be billed differently. And you'll say, okay, perhaps that would be discrimination, but ultimately, if you're not profiling your clients to understand what bills they're able to take, to understand that if today perhaps I'm billing lower than I will bill a client who's already established, when this client is established, they will then be, it will be upon them to be able to get services from you at the rate that they should get at the level that they're operating in. And for many of these companies, understanding the nature of a client when they come to you is very, very important, because many of these clients, especially if you're advising a startup, let's say in the technology space, many of these entities, in just a matter of weeks, some of them months, will be valued at 3 times, 4 times, 5 times the amount of money that they were valued at the time that they came to you. So ultimately, if you're more specialized, it's also easier for you to be able to just, and I think the lady that spoke here earlier really hit the nail on the head, saying that ultimately, if you're billing, the bill will be for your expertise and your experience, rather than actually the work that you have put out. Because the way that you break down the law, the way that you advise the client, and the ease with which they're able to then go through any challenge that they may have, or be able to go through their business without any hurdles whatsoever, I think would really make the difference for any client. And so that experience, especially if you're more specialized, I feel is truly, truly the way to go. And for my experience, we've seen that in specializing in certain areas, it gives you a leeway, it gives you an advantage over others, because then it's easier for you to be able to justify a bill that you will give to a client as compared to another practice perhaps that may not have the same expertise or experience that you do when it comes to billing. And so my request is that since we're speaking at a Law Society event as well, and I'm glad that Shez is also the Vice President of Zanzibar Law Society. If we have all these committees on professional development, why don't we have committees that look at billing? Not only within our law firms, but also within the society as well. That would be able to give guidance. And I liked what Sandy from ABC mentioned about the UK bifurcation, I think, act where they separated the solicitors and the law society in terms of regulating lawyers and the business of law. If we had this in our societies and in our law firms as well, I strongly feel that will help us be able to build better, that will help us to have uniformity in the building, but also to guide and perhaps eliminate this undercutting or this underbilling thing that I think has plagued this society and many other societies as well. I think that's what I would say, Aisha.
Hello, can you hear me? Mine is just a quick comment in terms of what has been called undercutting. I just want to dissect it a bit further. I think we've looked at it from the angle that it's the competition between us that leads to undercutting. I want to cut him, I want to undercut him, I want to undercut Kenya. But I think there's a recent trend whereby it's the clients now that are causing the undercutting. A lot of large corporations who have a large number of law firms on their panel have now created what they call, Elizabeth, what do you call it? Bidding. So they float a certain amount of work or a certain specification of work, and then they ask probably a cross-section about 4, 5, or even 10 law firms to bid for that work. Okay? And then what happens is that because everyone wants a piece of that pie, then everyone goes in to actually undercut, because price now is the only determining factor, not the competence, not the ability to do the work. And we've had this engagement with quite a lot of clients, and you really can't blame them as well, because why? They have also now compartmentalized their institutions. For example, for certain financial institutions, you understand that the legal departments, which would understand which lawyer, based on what experience or location, is best placed to do a certain assignment, don't have the mandate to make that call or decision, but rather it turns out them to their sourcing or whatever department that actually runs it. And even for some institutions, we've come across situations whereby the person who makes the decision as to which lawyer is going to do that and that meeting is someone based perhaps in Mauritius or somewhere else, and you don't have that choice. So then where am I going with this? Lawyers, in East Africa and I believe the rest of Africa have to look or relook at the laws that govern our billing, remuneration, so that we have those minimum caps and their enforceability to ensure that we don't actually undercut ourselves, all of us, into the market, out of the market. After all, it's a business. Thank you very much.
Thank you to all the presenters for the nice presentation. My question goes to Kenneth. You explained that maybe sometimes you have a client and they're just starting out, so you can charge them less with the hope that in the future they're going to generate more income and you could increase your bill. But my question is, I think sometimes that client might kind of see that you're trying to overcharge them, and they feel that you charge me for this, and now just because I'm earning more, you want more. But maybe your services are maybe priced at this amount, so you're just taking advantage of me. What is your response to that?
Again, more of a concern and a brain teaser. I stand to be corrected. To me, GN number 264 or 263 sometimes of 2015 is more confusing on fees chargeable or how to charge fees. Though my friend Munuka advocate said that it is very clear, the law is very clear on how to charge and the scales of charging. But to me, it's very unclear. To me, GN number 118, specifically Regulation 72, is more clear and very straightforward than GN number 264, because under that Regulation 72, it is one of the duties of advocates to charge fees that are reasonable and fair. So Regulation 72 says what is reasonable and fair and what factors are to be considered for fees to be reasonable. One of it is the weight of the matter or the sensitivity of the matter, which if you go to the advocate remuneration order, it doesn't say, this word excuse me, contentious and non-contentious. Now, my concern here is a civil matter a contentious matter or non-contentious? Does the advocate remuneration order say specifically for this, because I know with contract it says for this value of the contract, you charge this percent to this percent. Now, for civil matters, does it say, how does it give a criteria on how to charge for civil matter? Because sometimes a client comes with his matter and he wants you to go to the High Court because it has jurisdiction. But the fees that you're charging, you cannot charge him or the client cannot charge him the fees that you charge to the High Court, because even the subject matter does not have that value, for example. So that is my concern on the, you're saying it is very comprehensive, but I don't think if that is so. I stand to be corrected. 1. 2, what would you advise this young practitioner who says the client has approached him and he has a transaction of 1 million, but he wants to pay him 5 million? this young practitioner has come from your office, maybe you've not paid him a salary for lack of business for sometimes, and he has 5 million on his table. What would you advise him to do in these circumstances?
So last question.
Mine is not a question, but just a complementary to what Council Jose Numani was explaining about the bidding processes in these organizations. I am an in-house counsel, and I work for one of these organizations. And one of my biggest headaches is legal costs. And we have a situation whereby strategies, bank strategies or financial institution strategies are against, or rather are not in favor of what we call the sort of policies, processes, and procedures that have been placed in terms of advocates' remuneration. So for instance, if I take a look at what we have as recent directives from the Bank of Tanzania, the Bank of Tanzania wants us to reach an NPL ratio of 5% at the end of December 2022, and they want us to reach a cost-to-income ratio of 55% by the end of 2022. And if we do not reach those ratios, then we will not be able to pay bonuses, nor be able to pay dividends to our shareholders. So I think you understand from a shareholder's perspective, from a board of directors' perspective, they will definitely be hard on the management of these financial institutions to ensure that they control their costs as much as possible. And in order to increase their income, in order to make sure that we reach these regulatory ratios that have been placed for us. But I'm not saying that we shouldn't comply and we should not respect what us as lawyers. Because there's another difficult, another challenge is that yes, you're an in-house counsel, but then you work for a bank. So then that's difficult to balance. But if the advocate's remuneration order, for instance, I do not see its enforceability, because what happens when you come out in the practice, you, I could say that you give up the advocate's remuneration, because, for instance, we tell you that we want you to bill such and such fee for the, your representation at the High Court or the Court of Appeal. So, because the remuneration laws do not have some form of teeth if you're not complying to them. So you definitely just give in because you want business, and that is the sort of balance, or rather the undercut. We're not exactly promoting the undercutting, but it's because of the nature of the businesses of the clients that we serve, or the clients that you serve on our behalf. Thank you.
Last one.
I raised my hand first. Just because I'm the host, you were depriving me. Okay, so I actually first raised my hand to ask you all to please give Ms. Madeline Kimei a big round of applause, because she just got re-elected as the president of the Tanzania Institute of Arbitrators. So, Madeline, congratulations for, again, being the president. But I also, so one of the main reasons I'm very passionate about this subject and why we candidate this LawCon is because you can see how disturbing this advocate remuneration issue is. I think it's not just for Tanzania, but for many other countries. So, I have a couple of questions. Not a question, but it's a suggestion where maybe you can comment on. So, firstly, I think where we're heading at and the kind of clients we have in Tanzania specifically, I think we should have contingency fees even for the legal practitioners, because very few clients can afford to pay legal fees. And although we say it's not, it's against the law, but I know majority of legal practitioners are doing it. Okay, so why not legalize it? That's one. Two, again, third-party funding. I think, again, for Tanzania, this should be allowed for even the other legal cases. We have some really interesting cases out there where you clearly know that the client can win this case, but doesn't have the funding. So I believe that these things should be legalized. I don't know what your opinions are, but I think they should be legalized. And definitely, we should consider, as what Kenneth said, is looking at some level of sharing or standardizing certain fees so that we are not undercutting each other, or, as what Aisha said, we're not over-benefiting from other clients. So those are my comments, and probably you can give your thoughts. Thank you.
Thank you. I think we can start from here, from Henry, and then last attempt.
Thank you. First and foremost, I will start with Shehzad's comment on the issue of third-party funding. If you read the regulation 78 of GN 118, it provides for fees and expenses paid by someone other than client. And however, it just suggests that whenever that third party, pays for the client, there has to be a written consent from that third party. So this GN allows that. Coming back to my senior brother, Advocate Barnabas Nyalusi, he mentioned that he believes GN 264, the remuneration orders, are rather confusing and that they don't provide the clarity that I suggested. Of course, that was my opinion, and I respect Senior Barnabas Nyalusi's opinion as well for the reasons he has raised. However, if you read the provision of Regulation 72 of GN 118, it also provides that even though an advocate is supposed to charge, has a duty actually to stipulate or charge or accept only fees that are fully disclosed, fair and reasonable. If you read Regulation 2 of the same Regulation 72, actually paragraph H, it says that in determining whether a fee is fair and reasonable, the following factors should be considered. And paragraph H says, scales authorized by Chief Justice. Now that's where we go back to GN 264, because that GN 264 actually is what is reflected, or is what has a relationship with this provision that I've just mentioned. Now, if we didn't have this provision which says that scales authorized by the Chief Justice, then I would have agreed with you absolutely that the provision of Regulation 72 standing alone would have been more clear. On the question of a young practitioner who actually has came across a client, a 1 million client, and then this client can only pay 5 million for the transaction of that much. And you said that this very young practitioner has not been paid either, let's say salary, I don't know if it is salary, or for that case, been paid for whatever that he has to do for life. What would I advise this very young practitioner? I mentioned the other time when I was presenting that sometimes we have a conflict between the right to survive and professional ethics. Because at that point, now we are putting this young practitioner at the middle of those two competing interests. One, to abide by the rules, but two, this guy is hungry. And not only hungry, sometimes this other young practitioner also have their siblings that are depending on them. So it is, sometimes it is a struggle for existence rather than the issue of abiding by professional rules. However, even in the hardest of moments, I would urge that we as professionals, we should actually abide by these rules, because these clients will also inform another client that you can actually have this very service for a minimum amount, because lawyers have nowhere to go. So we will have to fight hard, and it's not easy, but we have to, if we really have to make a profession, because I can't picture 50 years to come if we continue this trend. Thank you.
There's a recommendation to relax the doctrine. I think the UK, who we have heavily relied on in terms of legislating our civil procedure and our practice as common law lawyers, have relaxed the rules attached to having contingency fees. And although the doctrine of champerty still exists in the UK, and if you look back to Singaporeans, they have somehow loosened it up and eliminated entirely the rule with regards to champerty to allow for more certainty for arbitration practicing and allowing that competitiveness to be internationally recognized. And so for Tanzania to build itself as a hub or as a seat, a preferable seat, these rules will need to be relooked. And with that said, I'm not for freeing it up entirely, but to have maybe some or bio-regulations that would require the lawyers to disclose to the arbitral tribunal that we have this funding. It's being funded by X, Y, Z, and so on and so forth. So that disclosure is key. And secondly, and this is from a report from a recent study from our Hong Kong colleagues, who are also common law based, they've recommended that the lawyer's duty to act in the best interest of their client needs to be cemented when that disclosure is made. Because of course, as we understand, the CFA somehow has these ethical attachments to the threat. That's why we have the position that we do. And so that's really what I would add on to that. But for us to welcome TPF, third-party funding, yes, the order speaks of someone else, but there's been no acceptance within the Arbitration Act itself of usage of these third-party funders. And they're modeled differently. They're not insurance companies where they ensure that we will pay the fees, but they're slightly more looking at whether there's success in the case. If we do fund you, do we have that probability of success that would ensure that we will recover the sums that we have funded the case for? So they do a deep dive, and so they're just not somebody. They have their what's this, part of the buffet at the end of the day, and so that also that dynamic plays to be a very important dynamic to consider, and to have regulations specifically set for this someone else that is being discussed in the remuneration order.
Thank you. Mine was a question on startups, I think, in terms of charging. Before I got married, I told my wife that one, I love to hike and I love to climb mountains. And I told her at any time after we get married, should you want me not to hike or do those things, you'll be breaching a contract. So if many years down the road, anything was to happen, I already communicated exactly what I wanted before the relationship happened. Same thing with billing. If you have a client, especially a startup, and if you understand exactly what your business is and you know your worth in terms of billing, if you tell a startup that, look, this is what I ordinarily charge, however, I understand that you are a startup and you need to be able to save on costs, this is what I will charge you, but in 6 months, in 1 year, in 2 years, I will be able to review this figure and we can agree on a higher figure. If that client at that particular point started to complain that you're billing them more than what you're billing them before, maybe because they've gotten money, they will really, that's a client who perhaps is among that category of clients that you should not be with. I think the branding gentleman here mentioned that very clearly. So I would say communication is very key in billing clients of that nature. I think there's even an African proverb around that. He who explains to a client the bill will bill higher at a later date. Thank you.
Thank you very much. Thank you, my dear panelists. I think we have had a very fruitful discussion, despite the timing, but the audience was very much awake and they have participated fully to the session. So a big round of applause to the panelists and another round of applause to the audience. Thank you all, and this marks the end of our session this evening. Thank you so much, Shazada and Stadio, for this wonderful opportunity and giving us space to discuss and ponder on issues which are very dear to us as lawyers. And I hope these conversations don't end here and we do take them further for the betterment of our profession. Thank you.